Your Honours, ladies and gentlemen, welcome to the second Selden Society lecture in the 2015 series, 7 English Judges. May I extend a particular welcome to new members of the Society who've joined since our last lecture. The Society is a charity and really values the members who join us. Tonight we move forward from the England of Sir Edward Coke to a pivotal period in English history, the 1700s. This was a challenging period for the common law because of the great changes which occurred in English society. Prior to this period, England was essentially a rural society, served by relatively small urban centres. London itself had a population of only about 600,000 in 1700. During the 1700s, however, a series of interrelated movements transformed the country. Developments in technology led to the birth of a manufacturing industry and the growth of cities and towns. Accompanying this development was a sharp rise in international trade. This growth in commerce in turn led to a greater dependence on the insurance and finance sectors of the economy. At the same time, a growing social consciousness called into question the morality and legality of some of the practices, such as human slavery, upon which this wealth was being built. So it fell to the common law of this period to seek to respond to these rapid changes in society, to enforce rights, but also to define their limits. The key figure in this period of English legal history was a long-serving Chief Justice of the Court of King's Bench, Lord Mansfield. To explain the role of Lord Mansfield in this pivotal period of English legal history, we're honoured to have as our speaker tonight, Associate Professor Warren Swain. Professor Swain's career began at the University of Oxford, where he completed his primary degree in law, followed by a BCL. He then taught at Hertford College while completing his DPhil. In more recent years, at the University of Queensland, Professor Swain was able to finish his masterpiece, The Law of Contract, 1670 to 1870, which was launched by Justice Jackson in the Supreme Court Library earlier this year. Needless to say, the judgments of Lord Mansfield figure prominently in the study, so we're indeed fortunate to have Professor Swain speaking to us tonight. Please welcome Associate Professor Warren Swain.
Thanks very much, John. It's not difficult, perhaps, to see why Lord Mansfield is one of the judges chosen for this series, though there cannot be too many judges who have had poetry, albeit to doggerel, composed in their honour, nor a ship named after them. And indeed, more than 200 years after his death, Lord Mansfield continues to fascinate. A recent cinematic entertainment featuring Lord Mansfield even enjoyed some small success at the box office. Ever since John Holliday produced his A Life of William, late Earl of Mansfield in 1797, a work described by Lord Campbell, of all people, as the worst specimen of any biography to be found in any language, a great deal has been written about him. The most recent addition to the genre appeared as recently as 2013. Today, I am going to concentrate on those judgments of Lord Mansfield which were concerned with commercial practice and the law of contract, rather than going into great detail about the life of Lord Mansfield. Unlike the previous judge, Sir Edward Coke, Lord Mansfield's personal life was rather less fascinating. Nevertheless, a few facts should be mentioned before discussing the way in which Lord Mansfield shaped English law during his tenure as Chief Justice of the King's Bench. William Murray was born at the Palace of Scone near Perth in 1705. His father, the 5th Viscount Stormont, was a leading Jacobite sympathiser. After the failure of the 1715 rebellion, Murray's elder brother, James Murray, followed James Stuart, the old Pretender, into exile. William, meanwhile, left for London. After an education at Westminster School, he went up to Christ Church, Oxford in 1723. He was admitted to the bar at Lincoln's Inn in 1730 and slowly built up a practice which initially involved specialising in Scottish appeals in the House of Lords and colonial disputes. Before very long, he was in demand as a Chancery barrister and indeed had a very large and prosperous Chancery practice. The firm grounding that this gave him in equity was something that would later on prove very significant when he was on the bench. In 1738, Murray married Lady Elizabeth, daughter of Daniel Finch, the 7th Earl of Winchilsea and 2nd Earl of Nottingham. Coincidentally, her grandfather, Lord Nottingham, was the great 17th century Lord Chancellor. And by all accounts, they were, unlike the Cookes, they were happily married until her death. There were no children. In the late 1730s, Murray seems to have been set on a political career. Through the patronage of the Duke of Newcastle, he was elected as a Member of Parliament for Boroughbridge in 1742 and immediately becomes Solicitor General. His political career at various points was slightly rocky because of his Jacobite background. Sir Dudley Ryder, the Attorney General, and Murray were involved in prosecuting the leaders of the 1745 Jacobite rebellion. Much worse was to follow in 1753, when his enemies alleged that Murray and some friends had, 20 years earlier, toasted the health of the old Pretender. Murray actually was investigated by the Cabinet and forced to deny these charges. Allegations here which might have ended his career, but instead he was promoted to the office of Attorney General, on Ryder becoming Chief Justice of the King's Bench in 1754. Ryder then died suddenly of fever just 2 years later, and Murray again takes over from him as Chief Justice of the King's Bench, where he served for 30 years from 1756 to 1786. He then, after retirement, dies at his home, Kenwood House, on the 20th of March 1793, and was buried in Westminster Abbey. I was recently fortunate to visit Kenwood House, which is in North London, and anyone gets the opportunity, it's worth going to see, partly because there are two wonderful portraits there. There's a Rembrandt and a rather nice Vermeer. Any trace of Lord Mansfield has been extinguished because the Mansfield's heirs hated living in London, preferring to live in Scotland, and from the early 19th century they simply rented the house out. In the 30 years that Lord Mansfield served as Chief Justice, his contributions were many and varied. Some of his judgments were undoubtedly controversial, such as his rulings on a charge of seditious libel against John Wilkes. Another well-known example that is particularly seen as significant in the United States are his remarks about slaves in Somerset's case. Though inevitably much of the work of the Chief Justice attracted much less public attention, and it is here that I will focus, particularly on the way in which Lord Mansfield not just shaped the direction of private law for a generation, but continues to be influential today. One of the other events that's noticeable in the 18th century, as well as the growth of cities and industrialisation and trade, is actually the growth in the number of newspapers. These provide a useful source of information about Lord Mansfield, not all of it entirely accurate. But by the 1770s, there was much speculation about the Chief Justice's health and possible retirement. He was a popular subject for the popular press. Certainly by this time his health was failing, and the London Evening Post even claimed that Lord Mansfield's nails had fallen out as a result of scurvy. Some of the comment in the press was critical. As a public figure, he could expect a certain amount of ridicule. There are, of course, some wonderful satirical 18th century prints of Lord Mansfield, often featuring Lord Mansfield wearing a Scots bonnet. But amongst the criticism, equally, the press was sometimes sympathetic. So the Public Advertiser reported in 1772, in the context of a story that Lord Mansfield had misdirected a jury, and it said, which of the judges has not done the same? Were the conduct of the rest as narrowly watched, they would be perhaps found much more blamable. Besides, who will pretend to be infallible? Lord Mansfield certainly will not assume the arrogance of the Pope. Certainly Lord Mansfield could count himself unfortunate to be one of the victims of the pen of Junius, the political commentator, who complained about Lord Mansfield that instead of those certain positive rules by which the judgment of a court of law should invariably be determined, you have fondly introduced your own unsettled notions of equity and substantial justice. In the meantime, the practice gains ground. The Court of King's Bench becomes a court of equity, and the judge, instead of consulting strictly the law of the land, refers only to the wisdom of the court and to the purity of his own conscience. The Public Advertiser, in defence of Lord Mansfield, advised Junius to learn a little more law before you attack the Lord Chief Justice. Yet some of these allegations undoubtedly did resonate with lawyers. When Lord Eldon recalled a remark that Lord Mansfield is supposed to have made to Chief Justice de Grey, that he never liked law as well as when it was like equity, he did not intend the anecdote as a compliment. Lord Eldon also regarded Lord Mansfield as a malign influence on his friend Justice Buller, claiming that when he was appointed, that is Buller, he was utterly unacquainted with equity, but was encouraged by Lord Mansfield to follow in his footsteps with loose, vague notions of equity. This strong association between Lord Mansfield and equity was carried into the 19th century by critics and admirers alike. Indeed, it's perhaps no surprise to anyone in this room that Lord Denning saw a parallel between himself and Lord Mansfield in the way that he perceived of his use of equity. And of course, the debate about the proper role of equity very much has contemporary resonances in Australia, particularly in the rather bad-tempered discussion about the place of equity in modern Australian law, especially in relation to unjust enrichment and restitution, to which I will return. But the discussion of the role of equity was part of a wider one surrounding Lord Mansfield's preparedness to countenance uncertainty in the law at the expense of precedent. In a letter to the London Evening Post, you see you can have lots of fun reading 18th century newspapers, the author, somewhat tongue-in-cheek, proposed a new style dictionary in a question and answer format. Various satirical examples were given, but one that we're interested in here was the response to the question, why is Lord Mansfield called the most learned man in the law? To which the answer was, because he condemns Coke and all the ancient rules, opinions and precedents of the law. In addition to Lord Mansfield's apparent liking for equity and supposed disregard for precedent, he's also credited with developing commercial law. Justice Buller is hardly an impartial observer, indeed was a close friend of Lord Mansfield's and left some money by Lord Mansfield in his will, described Lord Mansfield as the founder of the commercial law of this country. Others thought the same. The legal writer James Park dedicated the first edition of his work on insurance to Lord Mansfield with the words, "Your extensive knowledge joined to an unwearied application to every part of commercial jurisprudence has endeared your lordship to the name of the merchants of London." And it is this aspect, the way in which Lord Mansfield was supposedly the founder of commercial law of this country, which is the first of the three myths. To an extent, it's a myth that I wish to re-evaluate. Reading some accounts, it would be easy to conclude that judges before Lord Mansfield paid little attention to the needs of merchants. Yet actually, mercantile usage was influential long before Lord Mansfield's day. Of course, in the Middle Ages, merchants had their own courts. Admiralty courts which dealt with mercantile matters remained important, albeit diminished from the 17th century. But what of the common law itself? Well, in the 1670s, Sir Matthew Hale noted, the court used to ascertain themselves by speech with merchants or civilians, or else it comes in question upon the general issue. And then if it be a question touching the custom of merchants, merchants are usually jurors at the request of either party. And merchants produced on either side are produced to ascertain the court and jury touching the custom of merchants. And if it be a question touching marine law, merchants, mariners and civilians are heard. In other words, long before Lord Mansfield's day, there was a way or various ways in which merchants could influence the development of the common law. So mercantile custom might be raised in evidence during the course of trial. It was also possible to canvass mercantile opinion outside the courtroom. So on one occasion, Chief Justice Holt is reported to have said that he had all the eminent merchants in London with him at his chambers, and they all held it to be very common, unusual, and very good practice. Chief Justice Wiles explained in the 1740s that courts of law have always, in mercantile affairs, endeavoured to adapt the rules of law to the course and method of trade in order to promote trade and commerce instead of doing it any hurt. These remarks suggest that there was a long-standing willingness amongst judges to consider the needs of merchants. But at the same time, he was anxious that judges should be sensitive to mercantile needs rather than advocating a wholesale adoption of mercantile practice. Tellingly, when faced with one particularly tricky question, Chief Justice Holt, in 1703, consulted two of the most famous merchants in London and yet still reached the opposite conclusion. Even where the witness was as authoritative as the mercantile writer, there was no guarantee that mercantile practice would be adopted as part of the common law. Lord Mansfield was not the first then to recognise that the mercantile practice had a role to play in developing the law. It's sometimes assumed that Lord Mansfield was the first judge to really develop this idea. But in fact, it's less the existence of mercantile influence that changed rather than its extent. Lord Mansfield was perhaps even more prepared than some other judges to listen to the views of merchants and to receive mercantile opinion in evidence. Special juries made up of merchants in these commercial cases became more and more significant as a channel for the mercantile court point of view. So in a case like Lewis and Rucker, Lord Mansfield explained that they, the mercantile jury, understood the question very well and knew more of the subject than anybody else present and formed their judgment from their own notions and experience. Much of the work of integrating mercantile practice into the common law had been completed before Lord Mansfield was on the bench. The integration of bills of exchange and promissory notes into the mainstream common law began in the 17th century. But the process was not altogether an easy one. Promissory notes in particular were problematic simply because they look very like an ordinary contract. And the question then arises, well, if we need consideration in an ordinary contract, how do we justify a different rule applying in the context of promissory notes? This was something that gave Chief Justice Holt in particular sleepless nights. But it's less to do with Chief Justice Holt less to do with his concerns about listening to merchants, rather more than his concerns about the integrity of the common law and particularly the doctrine of consideration. Much of this work then was done before Lord Mansfield was on the bench. He can, though, be credited as far as negotiable instruments are concerned, with very much tidying up some of the existing anomalies and making these instruments work better and more consistently. Insurance litigation was increasingly common by the 1750s. John Westcott remarked that insurance is, of all the transactions among mankind, the most abundant source of disputes and perplexities. A vibrant marine insurance market existed in London and other major ports. Fire and marine insurance policies were very well established by 1750. Life insurance became increasingly popular. In early centuries, insurance contracts had fallen within several different court jurisdictions, but by the 17th century, they were usually litigated in the common law action of a subset. Yet at the same time, this was an area of the law where, as Park explained, there had been but few positive regulations upon insurance. The principles on which they were founded could never have been widely diffused nor very generally known. The task of developing this new, modern, coherent law of insurance largely fell on judges. And Lord Mansfield here does play a significant part. Indeed, William Blackstone described recent developments in marine insurance as a very complete title of commercial jurisprudence. Thomas Parker maintained that Lord Mansfield had rendered the law so plain and clear. John Westcott was less sanguine. He said, what in any country could be more preposterous and intolerably grievous or more reproachful to a great commercial nation, in particular than that the administration of private justice in the affairs of merchants should solely be in the hands of inconclusiveness. That's perhaps a more realistic assessment of insurance in the mid-18th century. And indeed, Lord Mansfield himself, speaking in 1761, said that the daily negotiations and property of merchants ought not to depend on subtleties and niceties, but on rules easily learned and easily retained, because they are the dictates of common sense drawn from the truth of the case. There's nothing new in judges without clear legal grounding appealing to the doctrine of common sense. It was something that Lord Mansfield did on a number of occasions. 2 decades on, there was still much to do from his statement in 1761. He said all questions on mercantile transactions, but more particularly upon policies of insurance, are extremely important and ought to be settled. As with negotiable instruments already briefly touched upon, mercantile custom was very important in this particular type of contract. It wasn't so much as with the bills of exchange and promissory notes that there was an issue about whether the common law was the appropriate forum. This isn't doubted. The question is whether mercantile practice can be used to shape and direct the law. A dedication to Lord Mansfield in James Park's treatise on insurance, which I've already highlighted, stresses the way in which Lord Mansfield was seen as very important in this process. And it's an area in which commercial practice heavily influences the direction of legal doctrine. Special juries, as I've also mentioned, sat in these cases. Special juries made up of merchants. Expert witnesses were called from the insurance industry and from shipping industries. Underwriters and others were consulted informally. And in fact, John Westcott may even have had Lord Mansfield in mind when he complained that a judge may be as often misled as assisted by these extrajudicial and ex parte conversations. Lord Mansfield's claim that the law on insurance is the same all over the world, if not strictly true, reflected the way in which he was prepared to utilise a cosmopolitan range of sources. Insurance contracts were not unique in this respect, and one can look at Mansfield's judgments and find references to Roman law and civilian writers. In Goss and Withers, having sought the advice of Sir George Lee on Admiralty practice, Lee was a noted expert on Admiralty and ecclesiastical matters. Lord Mansfield cited Grotius, and various other civilian writers, and the Roman law on prize. Civilian arguments and civilian sources began to appear more freely in the arguments of counsel at this time. But it's much more difficult to be certain about the precise role that these civilian ideas played. In 1802, Justice Lawrence would state that the law of insurance was largely derived from foreign writers, but he made the claim in an attempt to discredit the old common law position that it was impossible to insure a profit. Some of the time at least, and I suspect a lot of the time, civilian sources were simply used to add lustre to arguments that were essentially taken from commercial practice. There may be more of a grain of truth in the remarks of the defence counsel in Goss and Withers, whose withering response to his opponent, who had reeled off a list of civilian writers, was as to Malloy and Malines, the civilian writers, almost anything may be proved by citation from them. Of course, perhaps the most enduring and significant insurance case of Lord Mansfield's time is Carter and Beirne, where Lord Mansfield explained and examined the nature of the contract of insurance. Insurance, he said, is a contract based on speculation. The special facts upon which the contingent chance is to be computed lie most commonly in the knowledge of the insured only. The underwriter trusts to his representation and proceeds upon confidence that he does not keep back any circumstances in his knowledge. To mislead the underwriter into a belief that the circumstance does not exist and to induce him to estimate the risk if it did not exist. The provenance of the duty of disclosure, for which Carter and Beirne is most famous, was not discussed, but an earlier decision, De Costa and Scandrett, which predates Lord Mansfield, bases the idea on a broad equitable notion the idea of fraud, which at this time in equity was a broad concept. And Lord Mansfield would claim that policies of insurance are more governed by principles of equity than anything else. Justice Yates, in contrast, would attribute the duty of disclosure to natural law principles. The basic requirement, though, of disclosure also reflected Lord Mansfield's understanding of how the insurance business worked. With brokers at the centre, reputation and trust were important. As Lord Mansfield explained in De Costa and Alcock, in insuring merchant ships, all possible information ought to be given to the insurers. The application of the rule in Carton-Bohème is really about risk allocation, and risk allocation is determined in Lord Mansfield's mind by looking at what trade practices were. Lord Mansfield evidently had a good grounding of commercial realities. These come up again and again and again in Lord Mansfield's decisions. They help him to shape the law that's already well established, as in the case of negotiable instruments, but they also help him to build the law, as he did in the context of insurance. None of these developments are really particularly controversial. The same cannot be said, though, of the way in which Lord Mansfield sought to utilise equity. This is a particularly significant issue within Australia because of the way the High Court have interpreted Lord Mansfield's judgments, in particular the way that Justice Gummow has interpreted Lord Mansfield's judgment in the significant decision of Moses and Macfarlane. There are other examples of Lord Mansfield's use of equity, several other good examples, but because of the relevance to an Australian audience, I will say something about Moses and Macfarlane. Because it reflects a wider use of equity by Lord Mansfield. What Lord Mansfield is essentially doing in Moses and Macfarlane and the other cases is using equitable doctrine and importing equitable doctrine and ideas into the common law. Moses and Macfarlane itself arose from a dispute about promissory notes. Jacob made out 4 notes in the name of Moses. Macfarlane, wishing to recover in his own name against Jacob, asked Moses to endorse them. By endorsing the notes, Moses as well as Jacob was potentially liable to Macfarlane. However, Macfarlane enters into a written agreement with Moses not to sue on the endorsements. Despite this agreement, Macfarlane brings an action in the Court of Conscience, which was essentially a very small claim court that was important in the 18th century, a kind of precursor to the county courts, if you like. And that court refused to receive the agreement in evidence and ordered Moses to pay. At the trial, Lord Mansfield ruled that on the merits of the case, Moses should be allowed to recover the money he is ordered to pay. And a verdict is given for the plaintiff, subject to the opinion of the court as to whether the action for money hadn't received was appropriate in this context. Several objections were raised, but perhaps the most important objection for our purposes is counsel's argument that no assumpsit lies except upon an express or implied contract. But here it is impossible to presume any contract to refund money, it's argued, which the defendant recovered in an adverse suit, namely in the Court of Conscience. And there are 2 passages here which have been repeated ad nauseum by Justice Gummow and others, which are key to understanding the case. In the first, Lord Mansfield tells us, if the defendant be under an obligation from the ties of natural justice to refund, the law implies a debt and gives this action, founded in the equity of the plaintiff's case, as if it were upon a contract, quasi ex contractu, as the Roman law expresses it. This species of assumpsit, for money had and received to the plaintiff's use, lies in numberless instances. For money the defendant has received from a third person which he claims title to, in opposition to the plaintiff's right, and which he had by law authority to receive from such third person. In a later passage, and I think this is the crucial one, Lord Mansfield expanded on the nature of money had and received. This kind of equitable action, he said, to recover back money which ought not in justice to be kept, is very beneficial and therefore much encouraged. It lies only for money which ex aequo et bono the defendant ought to refund. It does not lie for money paid by the plaintiff, which is claimed of him as payable in point of honour and honesty, although it could not have been recovered from him by any course of law. The importance, I think, of these statements lies in the way in which Lord Mansfield sought to find a coherent basis for money had and received, a coherent explanation, which he seems to, from those passages and others, think the action can be founded in ideas drawn from the Court of Chancery, drawn from equity. In a general sense, it might be said, well, Chancery rests on the principle of ex aequo et bono, but there's a more concrete link too. And the more concrete link is that there are actions in Chancery which are identical to the action for money had and received. And Lord Mansfield is using that link in order to develop the common law action. And in fact, in a very closely similar action to money had and received, the action for money laid out, Lord Mansfield said, it's an action for money laid out against a surety. Lord Mansfield said that as to the objection that the Court of Chancery is the proper court for a surety to be relieved in, there are many cases in which a court of equity may be necessary to come at the facts. Yet if a court of law is possessed of facts, I know of no case where it may not give relief by the action on the case. The action for money laid out had a direct equivalent. There's a bill in equity that looks just like it. Money had and received is at one remove, but it's sometimes likened to a bill in equity. And although there's no exact match, it covers much of the same ground as the equitable action. And money had and received here is described by Lord Mansfield as a liberal action, and it proves to be very popular. By the 1760s, it had the potential to grow into a broad remedy protecting against the unconscionable receipt of another person's money. And by the 1770s, although he still professed to be a great friend of the action, Lord Mansfield starts to become more cautious. There's a worry that money had and received has got too big, and it's undermining other actions. Not least of which is that it's seen as having a potential to upset commercial bargains, and it's seen as undermining the action of trover. Lord Mansfield, as you will all know, his judgment remains significant in the High Court of Australia. It's been used by Justice Gummow and others to argue that restitution reliability is based on the equitable principle of unconscionability. This is deliberately set up as an alternative to the principle of unjust enrichment that is favoured in England and was once supported in Australia. I've argued elsewhere and been cited by the High Court for saying so, that the High Court have got the history here right. I'm not, it should be said, advocating that this is a good approach for the modern law, but simply saying that Gumow's judgments in these cases is much stronger on the genuine history of Moses and Macfarlane than the late Professor Peter Burke's, which isn't to say that the modern law should be as it is articulated by Gumow. But historically, it seems to me, Justice Gumow has a better grasp of what Moses and Macfarlane is about. And what it's about is an equitable doctrine. It's not, though, Lord Mansfield's intention, and increasingly not his intention in the decade when he's coming up to retirement, to suggest that money had and received can be some kind of freewheeling action. Quite the contrary, he stresses that the action should not be extended, and he stresses the situations in which the action can be brought. In other words, there's a very, very structured discretion, if one can even go as far as to call it discretion. The history of Moses and Macfarlane, though, reflects a wider issue in Lord Mansfield's judgment. And that's the extent to which Lord Mansfield was prepared to utilise fluid notions, and the way in which Lord Mansfield was prepared to use ideas like equity, natural justice, conscience. There would be certainly some in the High Court of Australia, particularly in the Mason Court, who are keen on these ideas of conscience. But we need to be a little bit careful of looking at Lord Mansfield's statements out of context. In Anderson and Temple, for example, Lord Mansfield explained that the most desirable object in all judicial determinations, especially mercantile ones, which ought to be determined upon natural justice and not upon the nicety of law, is to do substantial justice. These words suggest the critics had a point, that actually Lord Mansfield was some kind of 18th century version of Lord Denning, and that he wasn't too worried about precedent. Care needs to be taken here, though, because Lord Mansfield's remarks on this and on other occasions need to be judged against the more fluid notions of precedent that existed in the 18th century, as opposed to the much more rigid system that comes in the 19th century that's more familiar to us today. The slightly haphazard nature of law reporting also allows a greater degree of flexibility when it comes to the interpretation of earlier judgments than was possible later on. And even a writer as conservative as William Blackstone stressed the value of precedent, but at the same time felt no embarrassment about admitting flatly absurd or unjust decisions need not be followed. This, you might say, is judicial activism writ large. Lord Mansfield's position, though, was a bit more sophisticated than this may appear, because Lord Mansfield on many occasions stresses the importance of legal principles. This idea that legal principles should be lifted from earlier authorities rather than just blindly following earlier authorities is quite a sophisticated notion. It becomes very, very important in the 19th century. But at the same time, Lord Mansfield, on other occasions, recognises the value of precedent. Not through unthinking adherence, but as a useful device for promoting certainty. And in fact, his views on this are quite nicely summarised in Jones and Randall in 1774, where he says the law would be a strange science if it rested solely upon cases, and if after so large an increase of commerce, arts and circumstances accruing, we must go back to the time of Richard I to find a case and see what is law. Precedent indeed may serve to fix principles, which for certainty's sake are not suffered to be shaken, whatever might be the weight of the principle, independent of precedent. But precedent, though it be evidence of law, is not law in itself, much less the whole law. Lord Mansfield was quite happy on some occasions to stress the value of certainty and stress the value of precedent, especially but not exclusively in mercantile context. As early as 1774, he states, in all mercantile transactions, the great object should be certainty. A few years later, he reiterates the point. I desire nothing so much as that all questions of mercantile law should be fully settled and ascertained. In the 1780s, he would warn, nothing is more mischievous than uncertainty in mercantile law, and that in all mercantile cases there were two objects, convenience and certainty. Particularly where the law was well settled, Lord Mansfield is very anxious to avoid undermining the law by evidence of contrary mercantile usage. He draws on mercantile usage where the law's uncertain or there's a gap. He's much less prepared to draw on mercantile usage to undermine or upset an existing settled rule. One of the difficulties, though, in examining the exact role that equity plays in Lord Mansfield's jurisprudence is that the term is a slippery one, as we might argue it still is. It's sometimes used by Lord Mansfield, undoubtedly, as just a word meaning the law needs to be fair or just. Whether these remarks signify anything more meaningful is difficult to assess. He's certainly not the only judge in the 18th century to use equity in this sense. And indeed, Blackstone again states equity is synonymous with justice. Nevertheless, the suggestion that Lord Mansfield was more radical than his contemporaries when it came to legal development, in other words, that the satirists were right, that he was willing to depart from fix certain principles, isn't entirely convincing. It's unwise to judge his statements against modern notions of precedent, but it should also be noted that you can distinctly see in the case law two Lord Mansfields. There's an early Lord Mansfield and a later period Lord Mansfield. And the later period Lord Mansfield is much more cautious. He becomes much more conservative, perhaps in the way that we all do with age. But it's very evident in the case law. To sum up, Lord Mansfield was recently one of the subjects of Alan Hutchinson's book, Laughing at the Gods, Great Judges and How They Made the Common Law. It's actually a very bad book. A very bad book. Though few would disagree that Lord Mansfield, unlike some of the more politically correct choices chosen by Professor Hutchinson, deserves to be included. At the same time, it's important not to press the case for Lord Mansfield too far. He's an important figure, yes. He's a significant figure in developing the law of contract, in particular in the 18th century. That goes without saying. But his case mustn't be pushed too far. Such an approach can only result in distortion because it has caused some scholars, indeed many scholars, to neglect the contribution of his predecessors, his contemporaries, and his successors. It also runs the risk of caricature. Like most judges, and indeed like most good judges, one might say it's bad judges who were almost always entirely consistent. He wasn't always consistent. Sometimes he favoured certainty, at other times he refused to be bound by precedent. He was prepared to borrow legal doctrine from the Court of Chancery, but when this threatened to get out of hand, he was willing to stress the limits of money had and received. This flexibility is a great strength. It's perhaps, though, the biggest tribute that one can make to Lord Mansfield and his influence as a judge, that more than 200 years after his death, thousands of miles away from his birthplace, he continues to be cited and discussed. Thanks very much.
Warren, on behalf of all of us, can I thank you so much for the effort that you put into tonight's paper, which you've made entertaining, informative and delightful to listen to. Thank you very much.
Thank you.
Your Honours, ladies and gentlemen, just a few things before we leave. The first thing to mention is that the library is working very hard on improving the Selden Society website on the library's website. So from next week, I hope you'll be able to find some new pages that will give you video links to these lectures, the transcripts of earlier lectures from previous years, and also a little bit of history about the Selden Society itself. The second thing to mention is that we actually have the courthouse in Emerald watching us tonight. This lecture is being streamed there in the hope that we can stream lectures of this kind around the state in future. The third thing is the library would invite you to drop in and see the Sir Harry Gibbs Legal Heritage Centre on the ground floor of this building, which has an exhibition recently opened about Lawrence Dawes' mural, which is on this level. The exhibition is called Into the Light. Thank you so much for coming. And I look forward to seeing you next time for our colleague, Dr. Andrew Stumer, his lecture on Lord Eldon, which is on the 23rd of July, same time, same place. Thank you very much.